Welcome to the fifth day of Washington Arbitration Week, third edition. My name is Jose Antonio Rivas. I'm the co-founder of Washington Arbitration Week, together with Ian Laird. And this third edition has been an incredible ride so far, and we are saving the best of all for Friday today. So we're starting with a panel, which is, I'm proud to say, is one of the topics that is more avant-garde of all the topics that we have been discussing. A year ago or 2 years ago, we did a panel on general mining and seabed mining, but this time we're focusing only on seabed mining. We have an incredible number of experts in Washington, D.C., and I do not want to steal our moderators' thunder. My task is simply to provide some general information logistically. After the panel, we will go into breakout rooms, and you will be able to meet the stars who are in front of you. And two, the most important part is to introduce our moderator, Patricia Cruz-Tranny. She is a legal counsel at ICSID, and she is one of the case management. She works at one of the case management teams. She joined ICSID this year in February, and before ICSID, she worked as an associate in the international arbitration practice groups of the law firms Jenner and Block between 2019 2022, and Foley Hogg between 2015 and 2019, both in Washington, D.C. So she is fully a Washingtonian. She began her legal career in international trade practice at Hughes, Halbert, and Reed, also in Washington, D.C. She holds a law degree from Harvard Law School, and she's admitted to practice in New York and in the District of Columbia. Most importantly for this topic, she has done research and written about seabed mining, and she very well knows the various aspects from jurisdiction, merits, and quantum in many respects, and that's why we were able to put together this incredible panel that is in front of you. So welcome, Patricia. Thank you for all the work in putting together this panel, and the floor is fully yours.
Thank you so much, Jose Antonio, for the kind introduction, and welcome to all our audience today. Good morning. Great to see everybody bright and early here, DC time. I'm sure we have people joining from elsewhere as well. Let me do a very quick introduction of our panelists so we can get straight to hearing from them. Our panelists have incredible profiles. I cannot do them justice in the time that we have. But I'm going to do a brief introduction, but I encourage you to talk to them in the networking session at the end so that you can hear straight from them about their work in international dispute resolution and arbitration. I assure you they have incredible trajectories and achievements that I will not be able to cover here, but that you could hear from them about. So let me first start with Tafadzwa Pasepanuchka. She is a partner in Foley Hogg's International Litigation and Arbitration Department. She chairs the firm's Africa practice, and she has extensive experience representing sovereign states and state entities before numerous international forums, including the International Court of Justice, the International Tribunal of the Law of the Sea, and arbitration tribunals. Tafadzwa has helped her clients successfully resolve complex multi-jurisdictional disputes concerning natural resources, mining, energy, the environment, the law of the sea, among others. So she's got a lot to contribute to this panel today. Up next, we have David Atanasio. He is a senior associate at Deckard. He concentrates his practice on international arbitration and international litigation matters, especially those with difficult issues of public international law or foreign law. He has a deep understanding of banking, finance, oil and gas, mining, information technology, as well as many other sectors in multiple geographical regions. We also have with us today Jim Burrows. He is the former CEO and current vice chairman at the international consulting firm of Charles River Associates. He holds a PhD in economics from MIT and has 5 decades of experience in business consulting and dispute resolution matters, including investor-state arbitration. He founded CRA's metals and minerals practice and led its litigation consulting practice for many years prior to becoming CEO. He also has extensive experience in all minerals and metals industries, including iron and steel, gold, silver, and for our purposes today, things like copper, manganese, and others. And last but not least, we have Chris Milburn with us. He is the managing director at Secretariat Advisors in Canada. He has 25 years of experience in the quantification of economic damages and the valuation of business interests in the context of international arbitration and commercial litigation. He has extensive experience in the valuation and quantification of damages relating to mineral projects all over the world involving many different kinds of minerals. He has been recognized as a leading damages and valuation expert by Who's Who's Legal since 2014, and he has been named to Who's Who's Legal list of top mining experts since the mining list included experts in 2019. So we have an extremely knowledgeable panel with us today. And just to set the stage for their presentations, I wanted to give a very brief overview of the topic. So why deep seabed mining? Why is this a timely topic, and why is it interesting? Well, as the world seeks to transition away from fossil fuels and towards renewable energies, the demand for certain minerals, such as manganese, copper, and cobalt, is rising sharply. The seabed in what we call the area, that is the seabed that is beyond the limits of national jurisdiction, is rich in these minerals and is therefore attracting the attention of both private and state actors. At the moment, deep seabed mining remains at the exploration stage, but exploitation may begin very soon. The International Seabed Authority, which regulates mining activities in the area, is expected to finalize the exploitation regulations by July of next year, so in just a few months. And once that happens, what we call the mining code, that is the regulatory framework for seabed mining activity in the area, will be complete and exploitation activities can commence. We're therefore expecting to see a lot of mining activity in the area in the near future. And to illustrate the magnitude of this activity, the area covers half of the Earth's surface, and already existing exploration contracts cover over 1 million square kilometers of the area. And that is still just half a percent of the deep seabed beyond national jurisdiction. So there is enormous room for growth in this activity, and given its scale, it will require very high levels of investment, as well as the participation of both private and state actors. There are 3 main types of resources in the seabed that have attracted interest. Those are cobalt-rich crusts, polymetallic sulfides, and polymetallic nodules. The extraction and processing of these resources isn't necessarily analogous to those of land-based resources. Their location, about 5 kilometers deep in the ocean, and their mineral composition mean that we need new technologies to enable their extraction and processing on a commercial scale. So this is a cutting-edge enterprise, not just from a legal, but also a technological perspective. So the key framework that is applicable to deep seabed mining in the area is the United Nations Convention on the Law of the Sea, also known as UNCLOS. And it establishes some key legal principles to keep in mind as you hear from our panelists today. One is that the area and all the resources in it are the common heritage of mankind. That is, no state and no private actor can unilaterally claim sovereignty over the area or its resources. Instead, we have one central body, which I've referred to previously, the International Seabed Authority, that regulates deep seabed mining on behalf of the international community as a whole. And to this end, the International Seabed Authority, or the ISA, operates a contract-based licensing system for exploration and ultimately exploitation of deep seabed resources. That means that private actors, corporations, can apply to undertake mining activities if they are sponsored by an UNCLOS state-sponsored, and it can be their state of nationality or the state of control. This sponsorship agreement creates a very interesting dynamic between the state and the mining contractor, with legal rights and obligations that we will explore in today's conversation. So with that brief introduction, let me pose the first question for our panelists. David, so clearly, as with any industry, especially one of the magnitude that deep seabed mining is expected to have, disputes are likely to arise at some point. Where can we expect disputes to be brought, and what kinds of disputes might these be?
Okay, thank you, Patricia. Good morning to all. So, as Patricia said, the area is the common heritage of mankind, but yet it is a potential source of highly commercial disputes. So I'm approaching this topic as an arbitration practitioner with experience in both commercial and investor state arbitration. We're currently at the cusp of an exciting new world with a plethora of potentially overlapping options for dispute resolution. I really want to approach this matter from the perspective of a commercial entity that may be engaged in commercial disputes with either the ISA or relevant state parties. Unlike in many settings, there are actually lots of options here for a company to seek formal dispute resolution, but there are actually also, very interestingly, a lot of options for the ISA or states. However, the means of dispute resolution in this area are effectively untested, and there are significant questions outstanding about how these different options may relate to one another and when they might be accessed. So our focus today is really on deep seabed mining in the area, because this is, generally speaking, where we find these polymetallic nodules, sulfides, and cobalt-rich crusts. And that's usually in the international seabed area, but not always. There are a couple areas of continental shelf, that is, well, areas closer to the coast of a relevant state that actually have some of these resources as well. The Cook Islands, for example, has manganese nodules on its continental shelf. But nevertheless, my primary focus will be on the area. And on the interest, while the dispute resolution mechanisms are quite extensive, in the interest of time, I'm going to focus only on dispute resolutions as they apply between private parties and their relationship with the various authorities, whether the state or the ISA itself. And this, we could really have a very significant range of different types of disputes, because the basic setup when you're a private party that's engaged in mining or exploration activities at present in the area is that you first have to get a state sponsor for your mining activity in the area, and then you have to enter into a contract or an agreement with the ISA that contains a plan of work. So you really have, whenever you have a private mining interest in the area, you really have a three parties involved at a minimum. So this private party may have disputes where it's the claimant regarding the plan of work or the implementation of its contract with the ISA. Could also have a dispute regarding contract modifications or terminations with its sponsoring state. You could have disputes regarding new laws or regulations imposed by the sponsoring state. But it's important to note that these a private contractor, or as they're sometimes called, could also be the respondent in disputes in this context. They often have payment obligations to the sponsoring state. That's often why the sponsoring state provides the sponsorship in exchange for receiving some payments. And they also have all sorts of environmental and other obligations that appear in other places in the contract that they enter into with the ISA agreement, but also in other regulatory documents that the ISA creates, and so on and so forth. So there's a lot of different types of disputes that can arise. Where do these disputes potentially get resolved? Well, I think in very broad strokes, the scheme set out in UNCLOS really contemplates that they will either go to the Seabed disputes chamber, and I'll get to what that is in a second, or to commercial arbitration. But I think there is a third option that perhaps as an investor state arbitration practitioner, I can't help but raise, and that is investor state arbitration. And we'll get to the context in which that might be an option as well. So first, let me start with the most unique dispute resolution mechanism that arises in this particular context, the Seabed disputes chamber. For arbitration practitioners, this may be the least familiar of the three mechanisms I'm going to discuss. So what is the Seabed disputes chamber? So this is a tribunal effectively, or a tribunal within a tribunal created by UNCLOS with exclusive and compulsory jurisdiction over certain categories of disputes. And this is unlike other dispute resolution mechanisms in UNCLOS related to other issues apart from the Seabed. It is formally a chamber of the International Tribunal for the Law of the Sea, but it's sort of a tribunal within a tribunal because it really does have its own separately defined jurisdiction. Thus far, it hasn't been terribly active. Its most significant decision, and actually only decision, is an advisory opinion on the responsibility and obligations of states sponsoring persons and entities with respect to activities in the area, which was issued on 1 February 2011. And one of the reasons it hasn't been so active is we are really just at the cusp of having significant mining activities in the area. There's a number of different exploration projects, but none of them have yet moved to the exploitation phase. So very interestingly, UNCLOS provides that the Seabed disputes chamber has jurisdiction over certain disputes involving private parties. This is the idea that private party can access this type of dispute resolution is fairly unique outside of investor state arbitration, perhaps not completely unique, of course, but it is not exactly commonplace, yet UNCLOS provides for it because it's envisioning here that private parties may well play a significant role in the system of mining in the area. So the Seabed disputes chamber has jurisdiction over sort of enumerated categories of disputes that can involve certain natural parties, and these natural or legal entities that are not state-owned. They are restricted to those entities that are actually sponsored by states. Only they are going to be able to access the system. And largely speaking, those are also the only entities who would really have any particular interest in needing dispute resolution before this system. So those entities are able to be involved in disputes before the Seabed disputes chamber involving the interpretation or application of a, and I quote, relevant contract or plan of work. They can also be involved in disputes regarding the acts or omissions of a party to such a contract relating to its activities in the area and directed to the other party or directly affecting its legitimate interests. When a private entity is involved in negotiating a contract or seeking a contract that has been sponsored, and it's already been sponsored by a state, it can actually have bring a dispute with the ISA to before the Seabed disputes chamber concerning the refusal of a contract or some legal issue arising in the negotiation of the contract. And finally, they can also bring disputes regarding various forms of liability of the international, the ISA. So, there's a fair number of types of disputes that can be heard before the Seabed disputes chamber. And very interestingly, the decisions of the Seabed disputes chamber are pursuant to UNCLOS are enforceable as judgments of the highest court where enforcement is sought. For those of us who do a fair amount of work in investor state arbitration, this may sound somewhat familiar. This is very roughly analogous to the enforcement terms of the ICSID convention. yet this is in UNCLOS and applies to the Seabed Disputes Chamber. So again, all of this is untested. And one very interesting question that I think arises in this context, although more in theory than in practice, is how the Seabed Disputes Chamber might obtain jurisdiction, especially if a private party is a respondent in an arbitration, how it would obtain jurisdiction over that private party, given that the party is not a contracting state of UNCLOS or any of the other relevant treaties that are that make up this particular framework. Of course, generally speaking, in international law, international arbitration certainly, but even in international adjudication more generally, the fundamental basis of jurisdiction is consent of the party, and it would seem that the private party has not given consent here. Now, one commentator says that we can say that the state of the party, of the private party, may have said to have given consent on its behalf or otherwise to have bound it. And I think that's a very interesting possibility. But in practice, this issue may prove less important because generally speaking, when you start to, at least once you've entered into a contractual arrangement with the ISA, the standard contract terms are going to actually say that say that disputes will be resolved pursuant to the terms of the relevant section of UNCLOS. So, as I said, the Seabed Disputes Chamber and its jurisdiction over these types of disputes is unexplored just because of where we are at the early stage. But it has great potential, especially once you look at the enforcement prospects for decisions that it makes. Now, one of the major alternatives to dispute resolution before the Seabed Disputes Chamber is commercial arbitration. And UNCLOS itself actually envisions dispute resolution through commercial arbitration. It says that disputes concerning the interpretation or application of a relevant contract between state parties, the authority, state enterprises, and natural or juridical persons shall be submitted at the request of any party to the dispute to binding commercial arbitration unless the parties otherwise agree. So it provides for commercial that commercial arbitration is one way in which one of those categories of disputes that I mentioned previously may be resolved. And in fact, it even goes on to say that if a contract lacks an arbitration clause that specifies a procedure, arbitration shall be carried out under the UNCITRAL rules. Doesn't specify whether this is supposed to, provide sort of a standing consent. It's not explicit on that. It just says that the arbitration shall be carried out in this particular way. But it at least seems to raise the possibility that one might argue that that the ISA might be able to that the ISA may be able to bring arbitration under its contracts with private parties, even though the standard contractual provisions simply refer to the general dispute resolution procedures in UNCLOS. Now, one wrinkle here about commercial arbitration in the framework of UNCLOS is that the Commercial Arbitral Tribunal specifically lacks jurisdiction to decide any question on the interpretation of UNCLOS itself. But instead, UNCLOS allows the Commercial Arbitral Tribunal to refer such a question to the Seabed Disputes Chamber. So it's sort of a referral mechanism, maybe something like we see in the European legal context, that allows the tribunal to effectively stop the proceeding and get a decision from a supposedly more authoritative body on the question. So one interesting question. So let me just then jump to the third option that we have here, which is investor-state arbitration. Investor-state dispute settlement may be another option depending on the precise nature of the dispute and the applicable treaties. Obviously, this is unlikely to be irrelevant for disputes with the ISA itself, or perhaps highly unlikely. because the ISA is not a state and is not a party to any international investment agreements. Instead, I think in the context of disputes in the area, investor-state arbitration is most likely to be relevant between a foreign investor and a sponsoring state. Now, it's worth noting that the sponsored party, sponsored private entity, must be a national sponsoring state and not under the effective control of a foreign state, which would seem to restrict, to some degree at least, the possibility of investor-state dispute resolution. But at least some of the companies that are already proceeding this with these projects, one significant example is Nori, which is sponsored by the island state of Nauru, is wholly owned by the metals company constituted in Canada. So let me just, I think I'll just wrap up with one interesting jurisdictional question here that I think arises if we were ever to try to pursue investor-state dispute resolution. Generally speaking, some tribunals have held that a nexus with the territory of the host state for the investment is required for an investment treaty to apply. Now, of course, the primary, a lot of the activity for an international mining project will be in the international seabed area, and this, of course, is clearly outside of any state's jurisdiction, just by definition. So some other nexus would be needed to a given state in order to invoke an investment treaty or ISDS. I think this particular issue is sui generis. That said, and I'll just leave you with this particular point, there have been a couple tribunals in a rather different context that have upheld disputes over jurisdiction over disputes where the investment took the form of contracts with the host state to perform custom inspection services outside of that state's territory. And perhaps there's an argument by some sort of analogy that a sponsorship agreement with a host state might qualify as a similar type of contract that could provide access to investor-state dispute resolution. Well, there's many other interesting issues I could talk about, but for the sake of time, I'm going to wrap up there and pass the floor back to Patricia.
Thanks, David. As you say, there's a lot of unexplored jurisdictional issues here that we could talk forever. But with that, transitioning from, you mentioned treaties and contracts creating rights and obligations for states and private actors. I guess my question for Tafatswa would be, what sorts of obligations might we see there, and what might that mean in terms for liability questions that might come up in the types of disputes that David has referenced?
Yeah, thanks so much, Patricia. And as a preliminary matter, I would note that if the seabed mining does proceed, we can anticipate a large number of disputes. We know that a large number of land mining disputes have arisen through ICSID. If we just look at ICSID, and you can attest to this, Patricia, but mining together with oil and gas make up a quarter of all of ICSID arbitrations. So there's a large propensity for disputes, and we are looking right now at disputes between a state and a mining company, but there are various other disputes that can arise. A state can sue the International Seaboard Authority, and a state can sue another state because of its actions before the seabed. And so there are a lot of different kinds of disputes. If you look just at the investor-state investor-state disputes that could come up with seabed mining, we see a lot of what we've seen on land, and these are disputes about whether or not a mining contract was lawfully terminated, whether a new regulation instituted by a state constitutes fair and equitable treatment or otherwise. And when you look at the actual language that states and contracting parties are and investors are including in their contracts, you see that it becomes very clear that we are going to see some of the issues that we have seen before. And I'll give one example, which is the Nauru Nori contract. This is one of about 31 exploration contracts that have been issued by the International Seabed Authority to date. As you mentioned, Patricia, they're all exploration contracts for now because there's no exploitation. but Nauru and Nori have now applied for an exploitation contract. And so looking at them at the Nauru situation is helpful. And if you look at the contract at paragraph 10.5, it says, in enacting and implementing Nauruan laws and regulations, the Republic shall at all times accord Nori fair and equitable treatment and will provide a stable and predictable legal framework and make decisions consistently and transparently and in accordance with the legitimate expectations of Nori and the Nori group. So right there, all the memories of FET in the land mining cases come to mind and clearly could be used as jurisprudence for deep seabed mining going forward. If you look at Nauru's law, it's seabed law. Every sponsoring state is required to have a seabed law before it actually sponsors a state. And if you look at Nauru's law, it also says at Article 30D, Nauru shall not impose unnecessary, disproportionate, or duplicate regulatory burdens on sponsored parties. Those are the investors. And even if you look at the advisory opinion of the ITLOS dispute chamber that David mentioned, you'll see that at paragraph 20, it says, reasonableness and non-arbitrariness must remain the hallmarks of any action by the sponsoring state of deep seabed mining in the area. So it's very likely that arbitrators and other adjudicators deciding whether states have violated the standard will look at the jurisprudence we have in land-based mining. And the cases are familiar to you all, but ACE v. Hungary, for example, Crystalex, Infinito Gold v. Costa Rica, Pacrum v. El Salvador, Bear Creek, which we will touch on more a bit later. And all of these cases make very clear that FET is a very fact-intensive, fact-specific provision, and it's never clear how exactly the arbitrators are going to decide on it, and they have exercised a lot of discretion. And so states that are entering into contracts with investors on deep seabed mining or promulgating laws related to deep seabed mining will want to be as specific as possible about what they mean by fair and equitable treatment or reasonableness. We're starting to see that now already with mining contracts on land, but it's important that that kind of clarity be included also in deep seabed mining contracts. States should be very specific about what they think that the investor should foresee and not see. I think it's telling that Nauru and Tonga have included express provisions that states are obligated to be reasonable and not act in a disproportionate manner. And yet others like the UK and Belgium have not opened themselves up to that risk. And so states have to be pretty look forward and look at the jurisprudence on land-based mining as they negotiate these disputes. And finally, one other similarity, and we know from, and we can expect from the land-based scenario, is that NGOs and other members of civil society can play an important role in the cases. We will probably see them acting as amicus, providing important details on context, and they can play a strategic role in supporting the states in cases in which the states are being sued by the investors. But there are also a couple ways in which deep seabed mining cases may present new matters on the merits as compared to some of the land ones. And a major one that I think we can't hide from is the fact that the resources of the area are supposed to be long and be used for the common heritage of mankind. And this is a fascinating principle and an important principle that many developing states fought hard for to be included in UNCLOS, but it's what it means remains very unclear. And depending on what it means, there may be various ramifications for how merits issues will be decided. We know in land-based mining that the issue of a social license for mining has come up. And this principle has been it was first included in Bear Creek explicitly, but other cases such as Copa Mesa and South American Silver v. Bolivia also consider the issue of the extent to which an investor should get some sort of approval or informal approval from the communities that are affected by its activities. And we've seen that tribunals are really hesitant to accept that an investor's failure to get informal approval will justify state conduct in terms of the termination of a contract, unless there's an express requirement for the investor to obtain that kind of a license. Now, with deep seabed mining, you have a clear obligation that the resources are to be mined for the benefit of the common heritage of mankind. So the social obligation is quite strong, but who can issue a social license on behalf of mankind? They may not be the local communities who are affected in deep seabed mining in certain locations. Some of it is in the middle of the ocean, but we know that the environmental implications could affect all of us. So do we all should we all be consulted as well? It remains to be seen how the International Seaboard Authority will look at this issue. And I think another question is just whether the International Seaboard Authority is self-granting a contract is sufficient social license, because it is supposed to be acting on behalf of us all. And so one could see investors saying, well, the fact that they got the contract in the first place means that they fulfilled the obligation to get any sort of social license that might exist. And finally, I'll emphasize that the deep seabed mining scenario remains is different in the sense of the level of uncertainty of the environmental harms that could be at stake because of mining. We know that environmental issues are a key aspect of land-based mining, but it's even worse with deep seabed mining because so much of the harm is unknown as of now. But we will expect that technical and scientific experts will be critical for tribunals trying to decide these issues. And tribunals may, even more than in the land-based mining scenario, try to get experts of their own so that they can make sense of the divergent opinions between investors and states as to the level of harm that could be arising from the activities. And you get a sense of how quickly the environmental situation is evolving, even with the contracts that have been issued to date. Earlier this year, Tuvalu rescinded a sponsorship contract that it had granted the metal company for exploration of minerals in the deep seabed mining because of its new understanding that deep seabed mining will have a negative impact on the environment. And that hasn't led to a dispute, but you can see that this kind of rapidly evolving situation with the environment can lead to disputes. And also, if we know that environmental laws are going to be changing and the understanding is going to be changing, this might affect the extent to which investors can effectively argue that they had the legitimate expectation that certain laws will remain the same when we know that the situation is evolving rapidly. But these are just some of the many issues that we can expect to see if deep seabed mining continues, and I'll stop there for now.
Yeah. So the overarching theme that I'm hearing, having heard from you and David, is that there's a lot of new ground, untread ground, in this type of dispute. Maybe we'll switch now to issues of quantum to hear first from Chris and then from Jim on whether there are similar novel issues on the side of quantum in this type of dispute. Maybe we'll start with you, Chris.
Sure. Thanks, Patricia. And it's a pleasure to be here. So yeah, I'm going to start, maybe start just with a brief overview of how the industry, where the industry is currently, and then I'll move into just discussing some of the valuation methodologies that I think tribunals might consider are appropriate and relevant to value a deep sea mining project in a arbitration dispute. So as Patricia mentioned, the main minerals that the mining and metals companies are interested in mining right now are these tennis ball sized polymetallic nodules that are literally strewn across the ocean floor. And they're particularly abundant in a region of the Pacific Ocean between Mexico and Hawaii, known as the Clarion-Clipperton Zone. And these nodules contain a mix of valuable metals, including cobalt, nickel, copper, manganese, and others, which are required for producing batteries and other technologies. The mining process entails basically scooping up these unattached nodules off the seafloor using unmanned vehicles, piping them up to a ship at the surface, and then transporting them to land, and where they'd be refined using sort of established processing methodologies. So work on collecting these seafloor nodules really began in the late 60s, early 70s. And at that time, the process was described as being like standing on the top of the Empire State Building, and you're trying to pick up small stones off the sidewalk using a long straw at night. So that's give you a sense of the level of difficulty of the process at the time. Now, the technology has advanced significantly since the 70s, and one mining executive says now it's really as simple as vacuuming golf balls off a putting green. But that remains to be seen, since the process has not been proven commercially as yet. So the proponents of deep sea mining say that the minerals, so the copper, the cobalt, nickel, manganese, etc., these are essential for a transition away from fossil fuels towards renewable energies. And that if we want to decarbonize and reach a net zero emissions by 2050, then we need to start extracting these resources from the ocean very soon. But as with most things, others question this and question whether or not deep sea mining is necessary at all in order for this transition to green energy. And they've expressed some significant concerns. Environmental organizations say that the risks of deep sea mining are enormous, since scientists aren't even sure what lives down there in these complex ecosystems. And some of the potential environmental risks include disturbance of fisheries, water contamination, sound pollution, and the destruction of the habitat of many species. So environmentalists, conservationists argue it would be reckless to go ahead with deep sea mining at this point with so much uncertainty and given the potential magnitude of environmental damage. But the mining companies argue that the process is actually less damaging than terrestrial mining for these battery minerals. And there is evidence that there are some ways to prevent some of the potential damages from occurring. There are a number of countries and large companies that share some of these environmental concerns. In August of 2021, the Northern Territory of Australia, they had a 9-year moratorium on seabed mining. They converted it into a total ban. Back in April, BMW, Volvo, Google, and Samsung all joined a World Wildlife Fund call for a moratorium on seabed mining. And these companies actually committed to not source materials mined from the deep ocean. So that could affect the market for those products. In June, Chile called for a 15-year moratorium, citing environmental concerns and a lack of sufficient data. And 4 island states, Micronesia, Samoa, Fiji, and Palau, are also calling for a moratorium on deep sea mining. But there's also significant interest and support for deep sea mining in from other areas. As been mentioned, the International Seabed Authority has actually issued permits and entered into 30 contracts for seabed mineral exploration. Of these contracts, at least 18 are held by just 7 countries. So China, France, Germany, India, Japan, Russia, and South Korea all are interested in deep sea mining. And 7 of the contracts are held by 3 private companies. So one is a Canadian company that's listed on the NASDAQ called the Mineral Corporation. One is a subsidiary of the U.S. Arms company, Lockheed Martin. It's called UK Seabed Resources. And the third is called Global Sea Mineral Resources, which is a subsidiary of a Belgian company. So those are kind of the players currently in the market. And just in terms of the status of the current projects, the industry, as has been mentioned, is at a sort of an early stage, a relatively early stage. So there are no commercial polymetallic nodule collection operations that have started anywhere in the world. A few projects are in development, but are still in the exploration stages. For example, the mineral company that I mentioned is developing 2 projects and targeting the Clarion-Clipperton zone. They've issued mineral resource statements and have conducted some initial assessments into the project economics, and they're actually scheduling commercial operations to start in 2024. But their disclosure to the market states that due to the preliminary nature of project planning and design and the untested nature of the specific seafloor production systems at a commercial scale, economic viability has not been demonstrated. So I think that's a pretty good summary as to where the industry is right now. And TMC and other companies can't proceed until global rules are established, as has been mentioned, which is we're waiting for that to be done by the International Seabed Authority, and that's expected to be released in June of 2023, although there is some doubt that they'll be ready by then. But even then, these companies will need exploitation contracts from the ISA, they'll need environmental permits and other permits and social license, which was, as mentioned, is a little, it will be interesting to see how that works. And so they'll need all that to operate commercially. So now I'll just turn to the valuation approaches that I think tribunals will consider in a dispute involving a deep sea mining project. So in valuation, there's three approaches that we use, and Jim will talk about them in some more detail, but there's the income approach, which is based on future cash flows. There's the market approach, which is based on market transactions, and then there's costs. And in mining, the appropriate approach that we use it depends on the stage of development of the project. So typically the income approach is not appropriate until you've advanced the project to a sufficient stage where you can forecast cash flows. So that's usually not until you've done a feasibility study. The market approach is always relevant, provided you can find market data that's from a similar project, which itself is very challenging. And the cost approach, typically only relevant for earlier stage products or projects, sort of prior to the definition of resources. To date, tribunals have been reluctant to apply the income approach of the DCF in mining cases and terrestrial mining cases that involve pre-production stage mineral projects for various reasons. And in many of the cases, the tribunals have based their awards on some costs. I do think the tribunals will be able to refer to the considerations and the criteria that are set out in awards for terrestrial mining cases to determine the valuation approaches that are appropriate for deep sea mining cases, because the underlying valuation considerations are largely the same. And just for example, in the Restoro versus Venezuela case, which involved a gold mine, the tribunal set out 6 criteria that they considered were necessary in order to apply a discounted cash flow, like an income approach to value a mining project. And I won't go through them all, but of those 6, 2 will be particularly problematic for deep sea mining at the moment. One is the need to show an established record of financial performance, since none of these projects have gone to exploitation yet. And 2 is the need for a predictable regulatory environment, which is not in place as yet, but all of that may change in the next few years as the industry continues to develop. And then given the significant environmental concerns, tribunals may also consider the Bear Creek v. Peru case, where the tribunal did not accept a DCF, even though that project had done a feasibility study and defined reserves, because they considered that the opposition to the project was so great that it made it highly uncertain that the project would have ever become profitable, even absent the alleged breaches of Peru. And then lastly, there is one ongoing investor-state arbitration involving seabed mining that provides some insights into the kind of valuation methodologies we can expect to see that experts will apply anyway. There's no award yet. And that's the NAFTA case between Odyssey Marine Exploration in Mexico. This case involves a seabed phosphate mining project off the coast of Mexico. So this is not international waters. This is in Mexico's jurisdiction. And the claimant's expert in that case used an income approach. They didn't consider market or cost. Respondent's expert argued that DCF is not appropriate because it's too early a stage. And they used the market approach based on the current share price and looked at the claimant's sunk costs. And that project was actually at a similar stage as some of these deep sea mining, like TMC's projects, where they have resources but have not yet defined reserves. They don't have feasibility of not established economic viability. So anyway, just looking at that case, it seems that the issues are very similar to terrestrial mining. In terms of the valuation approaches used by the experts, the arguments they've advanced in support of those methods, and the areas of disagreements between the experts. So anyway, so I'll stop there and pass it back to Patricia.
Thank you so much, Chris. I see already some questions coming in through the chat, so I want to be mindful that we have enough time at the end to answer those in the Q&A. So we'll get to that after we hear from Jim. So you've set up the stage perfectly for Jim to tell us about valuation methodologies that may apply here and how they might work versus how they work in land-based mining. So the floor is yours, Jim.
Thank you, Patricia. I just want to lead off with a couple of general points. First, I know that some of the people in the audience may have seen manganese nodules, but may have not, so I will hold up some actual manganese nodules. These are a little bit bigger than golf balls, a little heavier than golf balls. They're black, which is not surprising because they have a lot of manganese. These came from the Kennecott project in the 1970s. Which is a project we consulted on, and we actually still employ some people at CRA that worked on that project for Kennecott. So I've kept these on my desk for 40 years, and I finally had a chance to show them. A couple of other stylized facts before I give my answers. The manganese nodules plants, if they come in volume, will cause some disruption to markets, but the first plant won't. According to our calculations, if the technology works, manganese nodules production will be profitable enough to encourage a lot of investments in that area once the regulatory environment is straightened out. So with volume, you could start seeing impacts on markets, but if you just looked at one plant, the only metal that would be immediately disrupted would be manganese metal, which is primarily produced in China. Not manganese, not ferromanganese and manganese ores, but manganese metal. The other big one is cobalt. One plant would be perhaps 2.3%, 2.5% of world cobalt production, and then lesser amounts for nickel and molybdenum. So there is an issue of effects on land-based minerals production, but that would come into play probably after you had significant expansion of the deep seabed mining. So moving on to the quantum issues, I agree with everything Chris said in terms of the basic methodologies for quantum estimation. They're not fundamentally different for deep seabed mining as opposed to land-based mining, but there are obviously some challenges because of the fact that the technology is new and the forms might be different. On the market approach, there probably won't be much market evidence or market valuation evidence in the early days unless the project itself is a public company or unless there have been some transactions involving deep sea mining ventures. But in the early days, it will be very hard to use the market approach. You really can't do it by inference from land-based projects because they're just too different. So I would not recommend using information from land-based minerals projects to value an ocean mining project. The technology, the risks, and everything are just completely different. The income approach is certainly viable, although it has some challenges. Again, obviously, in the early days, there won't be any established record of performance. That's not a bar to valuation, but it's a hurdle that you'd have to persuade a tribunal that DCF would still apply, which tribunals have done many times for pre-production projects. The biggest one recently was the Tathian copper case against Pakistan. That was a pre-production project. It was after the feasibility study, and the award was in excess of $4 billion. So that was a case where a tribunal recently made a massive award a project that was not in production and had no revenue history or cost history. But that would be an issue that would come up in a case. And there are a number of other issues that would have to be resolved. First of all, as Chris mentioned, the technology is unproven. So there'd be an issue of, even if you have a feasibility study and you have cash flow projections, they would be based on assumptions about the technology working. And as we all know, when you have new technology, there's a high chance of failure. In fact, there's extensive literature, including literature we've done, looking at what's happened with projects with known technologies. And even there, you get frequent failures. Either the average overrun, almost all projects overrun, almost all projects have project delays of at least 2 years. And there are many examples of projects, land-based projects in the minerals area, using known technologies that basically didn't work and had to be shut down within a year or two. So this would be a bigger issue with ocean-based mining before there's any actual record of successful ventures. So there would have to be extensive analysis from an engineering perspective of just how reliable the technology, what kind of evidence that the technology works. So that's definitely a hurdle that would be at least more extreme for the case of ocean mining than would be for land-based mining. A third problem has to do with the projection of prices. If you're going to do a DCF, if you just have one project, you can probably base the economics on off-the-shelf price projections or projections done by analysts or projections based on futures markets, except for manganese metal, because the first project would account for over 35% of world manganese metal production. As I mentioned, that primarily comes from China. But if you have multiple projects, you start to have a problem because you wouldn't be able to use off-the-shelf forecasts for the market prices. You'd have to do a pretty detailed study. You'd have to take account of the fact that in many cases production is very concentrated with one or a few producers. So now you can't even analyze it as a competitive market. You've got to understand the market dynamics and how these producers would respond. So that becomes a big issue. There's also an issue with the cost of capital. There would be no information in the early days on the beta of it would be appropriate for ocean mining projects. Again, you couldn't necessarily use betas from land-based companies. You might be able to infer a beta from looking at covariance of metals prices, but again, if there's enough production, even that would be suspect. So there's an issue there. There's also obviously issues about the regulatory risk and the risk of the social license not being given. Even if the project is permitted and licensed, will there be enough opposition that it may never get off the ground? So all those issues have to be sorted out. So while a DCF is certainly feasible and conceivably all these issues could be overcome, the difficulties are at least different in magnitude than they would be for most land-based projects. Finally, for the cost-based method, it's likely to be the case that the cost for a single project would include a lot of costs for just R&D that are applicable to multiple projects or to other applications. So you'd have to sort out the project-specific costs versus these general costs. So there'd be a measurement problem there. But as I said earlier, none of these issues would be blocks. They're just difficulties. And smart people can overcome difficulties, but they would be different in nature from some of the land-based projects.
Thanks so much. It sounds like there's a lot of untread ground here too. The entire field sounds like it's ripe for practitioners and scholars to really contribute to the development of the law and expertise. I'm going to take a little bit of time to share some questions from the audience, and before we move to the breakout rooms or the networking session. We have a question that has been raised for Tafazzo and David. The question is, what could be some examples of state action related to deep seabed mining activities of private parties that could eventually be considered as breaching investment treaties? And I think some of that was already referenced in some of the discussion, but maybe to summarize it again for the audience.
Yeah, I can start. Thank you for that. I think looking at the contracts that exist now, the exploration contracts and the draft mining code that the International Seabed Authority has issued and that the states are negotiating currently, it looks like a lot of the disputes will be similar to what we've seen on the land. So whether or not a termination of a contract or a license is lawful, or is it an expropriation or not, or is it unfair in some way? Is it reasonable? We talked about Tuvalu rescinding its contract. Is that reasonable given what we know on the environment, or is that an unfair and inequitable action? There will be a lot of disputes on whether the measures that states are taking to protect the environment, which they're required to do under UNCLOS. They have to be sure that all of the activities of the sponsored states of the sponsored companies are promoting the environment, and so states have that obligation and will want to have certain measures that address that, but they must be proportionate to, and so there will be a lot of disputes, I think, potential disputes on whether the state's actions are actually reasonable, and so for that too, the jurisprudence of land-based mining will be important, with tribunals wanting to see what was the objective, was it proportionate, could anything else have been done before, and seeking expert advice and making those determinations.
Would you like to add anything, David?
Yes, just a brief comment, more on context rather than on sort of legal principle. It's sometimes said that less is known about the deep seabed than about the moon. So this is a rather unpredictable unknown environment. So just to take one I think, to me, very interesting example. You find some of these mineral deposits around hydrothermal vents. These are basically at the bottom of the ocean floor there, where hot water hits, I think, basically magma under the ocean surface, and then is ejected with a heavy mineral content into the ocean. And around these thermal vents at the bottom of the ocean floor, where there is no natural light arising, you get these collections of exotic life, sometimes microscopic, but I understand various types of worm-like creatures and things like that. And they all ultimately draw their energy from these chemical compounds rather than from the energy arriving from the sun, which really powers the rest of life on the planet. Mm-hmm. And both as an environmental matter, but also even as a scientific matter, these are quite interesting, because among other things, it may shed light on how life arose on this planet, or may have even played an actual active role in this. So there's the only point I want to make here is just that there's a lot we don't know, and a lot that we can also learn from this environment, which may ultimately be at the crux of certain disputes that arise.
Great, thank you. Just a quick word to the audience. Please feel free to send your questions via the chat function. You can send them directly to me if you prefer. We have another question. It's not addressed to anyone in particular, but the question is a state that is not a party to UNCLOS precluded from being a sponsoring state for exploration and exploitation in the area? I don't know if anybody wants to take a stab at that.
I can go ahead first. They are precluded from it. So a big state that's precluded is the United States. But as Chris mentioned, you do have Lockheed, which is a U.S. company. It's a UK subsidiary that's doing this, but you can have U.S. companies can participate as sponsored states. So one of the states that is a party can have a U.S. company participate, and so there are those kinds of linkages in which U.S. is still involved in this space.
Great. I don't know if anybody wants to add anything to that. All right. I'll give it a minute to see if we have any more questions come in through the chat. Otherwise, we can probably transition to our networking in a few minutes.
While we wait, I just wanted to make a comment on something that Jim said earlier, which I think is really fascinating about the impact of deep seabed mining on land-based mining and the potential impact of manganese and cobalt and of course for a lot of developing countries and African states in particular really fought hard to make sure that there would be some sort of compensation for that kind of impact on land-based mining. And if you want to read more on this, I would commend you to read Edwin Egede's book. I see that he's on the call, but he's written a lot about deep seabed area and negotiation under UNCLOS. But there is actually a provision in UNCLOS that requires those states to be compensated for the mining and the impact on deep seabed. And it's unclear as to now how they will be affected, but this will be an evaluation issue that comes up and that's been foreseen, and one of the many issues that the International Seabed Authority has to resolve in the coming year.
Thank you, Taffy. That's very insightful. I have another question. The question is, where can one foresee legal activism by environmental and social groups? Where would it take place?
I think we're seeing it at every stage. You're seeing it now because a lot of because of the level of activism of environmental groups, we're at a stage where it's suddenly it's more and more unclear when and if deep seabed mining will take place. Certain countries like France, who had initially sponsored states, are now saying it may be reckless to proceed with it. So there's a lot of activism by environmentalists and trying to show how much we don't know. 20 years ago, there was the understanding that there was nothing there, so we can do this, and this is going to have less of environmental impact than land-based mining. And now, because of what's known, it's clear that there's a lot we don't know, and clearly there's a lot of what's happening there is affecting the rest of the world, and we don't know those connections, and it's reckless to proceed. So you're seeing the activism by environmentalists in slowing down the action. A lot of NGOs are against this and are very vocal about it, prominent NGOs. And then I think you'll see them serving as amici in different cases, the way we've seen in land-based cases, trying to support state regulations that are on their environment. And it will be interesting to see if they can sponsor or work with states on advisory opinions and more direct access through the deep seabed mining, because of what David talked about. It's that there's the jurisdiction of the seabed authority is pretty broad, and you might see activism in that way as well.
Thank you, Taffy. We have, excuse me, we have a couple other questions. I'll put both to the group, given the time, and see what we can cover. The first question is, what is the role of landlocked states in seabed mining? And the second question is about the implications of the concept of common heritage of mankind to development in outer space, because outer space is also considered a common good, but there is less discussion on restricting development legally in that area. So one is the role of landlocked states, and the other is potential implications for the commercial exploitation in outer space.
Those are great questions. I I could start with the landlocked states ones. I mentioned African states, and I think Africa has the largest number of landlocked states of any region, and those states were quite vocal during UNCLOS, and I think one thing about this, the third negotiation of the convention, was the level to which landlocked rights were incorporated in the law of the sea. I think they will be able to sponsor companies. It's interesting that for now, the only region that doesn't have hasn't sponsored or has no activity in the deep seabed area is Africa, but then it may be caution from the states, it's unclear, or it may be development priorities, but they're the only region that don't have. But a landlocked state could indeed have a sponsor a state and conduct activities there. And because what the proceeds and of deep seabed mining are supposed to be for the common heritage of mankind, this is one of the issues again that have to still be resolved. But how then does everybody benefit, including the landlocked states, from the minerals that are mined and developed?
And I'll try to jump in and just make some speculative comments on the outer space element of this. Obviously, the major treaty governing outer space is the Outer Space Treaty, and it does not have any mechanism similar to the ISA, or really in any detail address the question of resources. And I think it does pose rather different problems in a number of different respects. First, you do not have the same potential environmental challenges or issues with outer space mining, if we're focusing on that. And second, you probably actually have a much more extensive set of resources even than are available in the seabeds in outer space, but at the same time, economically, probably much less accessible. Some private initiatives to the contrary. So, I mean, if the space technology advances enough that mining, say, asteroids starts to become feasible, perhaps some of the lessons that we will learn in the coming years from the operation of the ISA and the treatment, UNCLOS's treatment of the deep seabed may provide at least some guidance on how we might manage a resource scramble in outer space.
Thank you. And I think this probably brings us to the end of the panel before the networking. I hope everybody can stay at least a few minutes to to chat with our panelists in a more informal setting. But I just wanted to thank all of our panelists for their wonderful contributions. Obviously, this is an enormous topic we could talk about for days and days. So I thank you for giving us this glimpse into this growing nascent area of industry law. And just want to on behalf of everyone in the audience, I'm sure want to thank you for being here today and sharing with us.